You ever wonder why a leaky chemical drum on a factory floor turns into a court case years later? The answer is paperwork, and not the boring kind, the kind that can make or break your entire claim. Picture this, a company spills something nasty and suddenly there are inspectors crawling around like ants at a picnic. Those inspectors write down everything and that report becomes gold for your lawyer. The first big one is called a Phase 1 Environmental Site Assessment. It basically checks if a property has a history of contamination before anyone even digs a shovel into the dirt. Then comes Phase 2, which is the part where they actually test the soil and water. Think of it like a doctor ordering blood work instead of just guessing what is wrong with you. Lawyers love these reports because they show a timeline. If contamination existed before your client got sick, that is a problem. But if it spiked right when the company cut corners, that is a gold mine. Remediation reports are just as important, and people often confuse them with the testing reports. Testing tells you what is wrong, remediation tells you what they did to fix it, or in some cases, what they pretended to fix. You would be shocked how often a company says they cleaned up a site, but the follow-up testing says otherwise. That gap between promise and reality is exactly where lawyers build their case. Chain of custody documents matter too, even though they sound like something from a crime show. They prove the soil sample that says contaminated actually came from the property in question, not some random backyard 3 towns over. Groundwater monitoring reports are another piece of the puzzle, especially for long-term exposure cases. They track contamination over months or even years, kind of like a slow-motion replay of a disaster. Government agencies like the EPA often get involved, and their reports carry serious weight in court. If a federal inspector says there is a problem, that is way harder for a company's lawyer to argue against. Sometimes companies hire their own private testing firms, hoping for friendlier results. Juries are not dumb though, and a clear conflict of interest can blow up a defense fast. Historical land use records also help, because contamination does not always happen overnight. Sometimes it built up slowly, like that one junk drawer in your kitchen that somehow became a science experiment. There's also air quality testing, which matters a ton in cases involving fumes or industrial dust. People assume contamination is always about water or soil, but breathing in bad air can be just as harmful. Expert witnesses usually translate all of this lab speak into something a jury can actually understand. Numbers and chemical names mean nothing if nobody explains why they matter to your health. At the end of the day, all these reports work together like puzzle pieces, forming one big picture of responsibility. If you or someone you know has dealt with contamination and needs real answers, you want to learn more about our company, check out our links in the description.